Okay, so what are those 10 reasons? Well, from a defense attorney perspective, and mind you, this is from an applicant attorney's perspective of the 10 reasons that a defense attorney would schedule a deposition. These go as follows. And I might mention before I give you these 10 reasons that at the time I was given this material by an applicant attorney, both he and I had just sat through a deposition that was ordered by the defense attorney, and not all depositions go this way, but this particular deposition seemed to be particularly nonsensical. I was never really able to figure out what the defense attorney was after. It didn't seem that we spent much time discussing the merits of the case, and so both I and applicant attorney had traveled some distance to attend this deposition, and we were just kind of bewildered by the outcome. And so it was at this time that the applicant attorney gave me the answers to my questions. So that might give you some frame of reference or some context to put these answers in perspective. Okay, so reason number 1 that a defense attorney would call for a deposition has to do with finances, and that is attorney finances. Attending depositions allows an attorney to generate more billable work hours for the defense law firm. And I don't know about that. This is simply the answer that an applicant attorney gave to me. It certainly makes sense, but I neither endorse nor refute this as a reason for calling for a deposition. Reason number 2 that a defense attorney would call for a deposition is to harass the applicant attorney, hoping to consume so much of the applicant attorney's time to make the applicant attorney more likely to agree to a less than optimal settlement. Again, this is a financial reason, hoping to frustrate or delay, or in the words of this applicant attorney, to harass the applicant attorney, hoping that they can get a lowered settlement on the case. Reason number 3 that a defense attorney may call for a deposition is to prolong the litigation process to try and starve out the applicant. Now, mind you, this is all from the perspective of an applicant attorney. And it may be that this applicant attorney was on this particular day frustrated, but if you think about this, this makes sense. Calling for a deposition, it actually does prolong the process, or it can prolong the process. It can prolong the litigation, and meanwhile, the applicant, could feel starved out as time goes on indefinitely and ad infinitum. So that might actually be a good financial strategy, although probably a defense attorney wouldn't admit as such. Reason number 4 is to prevent the case from going to trial, or better stated, to create a reason that the case is not yet ready for trial. Another stall technique, another prolonged litigation technique. And then once the deposition is finally scheduled, the defense attorney could repeatedly reschedule the deposition, further prolonging litigation, further contributing to making the applicant feel that they are starved into accepting a smaller settlement. Reason number 5 that a defense attorney would call for a deposition, this involves a case where the QME report is unfavorable to the defense, and that reason is to try and get rid of the QME. And one of the ways to eloquently get rid of the QME, or elegantly get rid of the QME, is to make it impossible or improbable that the QME can attend the deposition within 120 days. Now, deposition timelines are governed by Labor Code, and the Labor Code requires that the deposition be set within 120 days. Well, if the QME evaluator is not available within 120 days, that QME evaluator can be dismissed from the case, in which case that would be an effective strategy of the defense in the case of an unfavorable QME report. Now, the opposite can also be true on the applicant attorney side, and I'll mention this as one of the 10 reasons that an applicant attorney may schedule a deposition or attempt to schedule a deposition in the hopes that the QME evaluator may not be available within 120 days. Now, what about those timelines? Well, deposition timelines are discussed under the California Code of Regulations, Title 8, Division 1, Chapter 1, 35.5. These are also known as the QME regulations. Well, Section F states as follows. It states that unless the appeals board or a workers' compensation administrative law judge orders otherwise, or the parties agree otherwise, whenever a party is legally entitled to depose the evaluator shall make him or herself available for deposition within 120 days of the notice of deposition. Okay, so the deposition must be set within 120 days. So, doctors, when you're called for a deposition, make sure that you give several available dates, maybe 5, 6, 7 available dates. Make yourself available within that 4-month time frame so that there's no way that the parties can't all agree on at least one date. Because otherwise, if you are the one that's unavailable within 120 days, well, of course, one of the parties may seek to discharge you as the QME on the case. Additionally, continuing reading from Section F, the evaluator shall make himself available within 120 days, and upon request of the unrepresented injured worker, the deposition shall be held at the location at which the evaluation examination was performed, or at a facility or office chosen by the deposing party that is not more than 20 miles from the location of the evaluation examination. So there is the answer to the question, where should the deposition be held? It's to be held at the location where the examination was performed, or at the discretion of the deposing party, can be at another alternative location no more than 20 miles from the location of the evaluation. So wherever it's held, you will be reimbursed for your mileage both to and from the deposing or the deposition location. Okay, reason number 6 that a defense attorney would call for a deposition is number 6, to try and attack the QME and the QME's qualifications, to undermine the credibility of the QME report. This, of course, would be in the case of an unfavorable report. In this case, an unfavorable report as perceived by the defense, by the insurance company or the defense attorney. Now, this might seem quite aggressive to try and attack the QME and the QME's qualifications and to try to undermine the credibility of the QME report. But I want to let you know that this has happened to me, and this is one of those reasons why there always is a little bit of apprehension or trepidation going into a QME report, because you have to anticipate in advance that it is possible that one side or the other is going to perceive your report as unfavorable. And if one or the other of those two parties decides, to take an aggressive stance against your opinion, this is one of the strategies to try and attack you and try and attack your qualifications and to try and undermine the credibility of your report. And I've had this happen to me. In the case that I'm referring to, it was an applicant attorney that really came out quite aggressive and did attack me on many issues. All of them, it seemed, were unrelated to the case in chief. So you need to be prepared for that as a strategy. And by the way, you don't have to put up with any attempts that another party might try to annoy, to harass, or embarrass you. And if you feel at any time like you're being harassed or embarrassed or annoyed, you can simply state, "Counsel, I don't understand your line of questioning, and it seems like you're trying to annoy me or harass me or embarrass me. And I just want you to know that I'm here to discuss the merits of the case, and I will not tolerate being embarrassed or harassed." Reason number 7 that a defense attorney could call for a QME is to try and befriend the QME and try and be very friendly and try and get the QME evaluator on their side and to try and get the QME to opine and lean in the favor of the defense attorney. And I've had that happen as well. It's never been overt. It's always been subtle. And don't be surprised if both parties seem particularly friendly to you. That's normal. At a deposition, you are the star of the show, and so all attention is on you. And so hopefully the parties will be friendly toward you. This, however, should not cause you to modify or change your opinions in any way. Reason number 8 is to throw you a curveball, is to present unexpected information without allowing you time to fully consider the information in the overall context of the case and also in the context of any previously submitted evidence. So in other words, it's designed to catch you off guard. It's designed to maybe make you feel a little bit intimidated, make you feel a little compelled to make on-the-spot or off-the-cuff determinations that you otherwise might not do. So you can anticipate this. You can anticipate that you may be given information, or you may be given a perspective, or you may be given some considerations that you previously had not thought of. That previously, because you are focused on being a doctor and attorneys are focused on being attorneys, you don't know all the issues that are going on in their mind and all the thoughts and considerations that are going on as they manage their cases. And so it is possible that you are going to be presented with information that comes to you as a bit of a curveball, as a bit of a surprise, as a bit of unexpected. That's okay. So when that happens, what do? You simply state that you need some time to consider that information, if you actually do. If you can comment upon it at the time and you're confident and you're well thought at the time, go ahead and comment. But if you feel that feeling in your stomach like, wow, I need to ponder this a little bit, feel free to always go ahead and say, I'm going to have to consider that and perhaps respond to that by way of a supplemental report. Don't feel compelled or pressured into making off-the-cuff determinations, because that is a strategy that a defense attorney could use, and also could be used by an applicant attorney as well. Reason number 9 that a defense attorney may call for a deposition is to try and wear out the QME. Quote unquote, wear them out. Wear them out. Tire them out. Wear out the QME by conducting a deposition that lasts for 3 or more hours even. maybe causing the QME to agree with the defendant in an attempt simply to end the deposition. Well, I've had depositions lasting more than 3 hours, and that has never really caused me to simply agree with anybody just because I'm tired, and that should not happen to you either. The point is, when you schedule a deposition, schedule plenty of time. I schedule an entire morning, 4 to 5 hours. And if it doesn't go that long and I get back to my office and I can resume my work, well, that's fine. But if it does go that long, I'm not surprised by it, and I'm not fatigued by it, and I'm not thrown off my game by it. Finally, reason number 10, and this is in the perspective of the frustrated applicant attorney. Reason number 10 why a defense attorney would call a doctor to deposition is to finally address medical legal issues. Now, what are the medical legal issues most likely to raise issues that would require a deposition? Well, like reasons 1 through 9 that we've discussed so far, reasons 1 through 9 actually either in overt or covert form have to do with finances, have to do with money. Well, the medical legal issues that you will likely be called to deposition for also are the issues that are most related to money, most related to the financial aspects of the case. And what are those? Of course, those are the permanent impairment, the apportionment of the permanent impairment, and to a lesser degree the future medical care. So medical legal wise, or speaking only of the medical legal issues, the number of reasons for which you're going to be called to deposition are finite. They're absolute. There's a limited number. It's not an infinite number of reasons. There's a finite number of reasons. Mostly has to do with the financial issues related to the case. And what are the financial issues related to the case? It's the permanent impairment, the apportionment, and the future medical care. And we will get into extensive discussions of those as we go here. Well, what about the applicant attorney?